Hello viewers, welcome to our program on Immigration and You. I am your immigration attorney Michael Fulwani, and once again we have with us my law partner David Nachman. David, welcome.
Thanks so much, Michael. Always a pleasure to be here with you.
So we start our today's program on the cutoff dates.
Before we start today's program, we want to make sure that we have everyone know that Michael was recently awarded a Lifetime Achievement Award by the State of New Jersey Bar Association. He's very humble about that, but this is an upcoming event, and we want to, not just myself, but of course the whole firm, and all of our viewers. I think I speak on behalf of all of our viewers in saying congratulations, Michael. It is a much well-deserved award that you're receiving, and congratulations.
And thank you very much, David. This could not have happened without your good wishes and good wishes of all our viewers who have been supporting us for many, many years. And thank all of you for that.
Thank you, Michael, for everything that you have done for all of our viewers.
Thanks. So let's start the program first with the cutoff dates for the month of April 2015. The family preference category, the first preference, which is for the unmarried sons and daughters of U.S. citizens, does not advance, and date remains the same, August 1, 2007. This is for all countries including India. Not a good news for the F1 category. The F2A category, which are the spouses and children under the age of 21 of green card holders, advances by 5 weeks to August 1, 2013, which is a pretty good news, I would say. For some time, F2A category has been advancing very nicely. So if you look at the August 1, 2013, the waiting period is actually about a year and few months, as against used to be 4 or 5 years in the past. The F2B category, which are the unmarried sons and daughters over the age of 21 of green card holders, is still a better news. It advances by 6 weeks to August 22nd, 2008 for all the countries including India. The F3, the married sons and daughters of U.S. citizens, advances by 2 weeks to February 8, 2004. And the family fourth preference, which are the brothers and sisters of U.S. citizens, advances by 4 weeks to June 15, 2002. Now, on the employment preference categories, the first preference, which are the priority workers, is current for all the countries. The employment second preference, which is for the advanced degree holders, is current for most of the countries except India. India advance is excellent this time. 32 weeks again. It was a big advance last time also. And the date is now September 1, 2007. So good news for a lot of our viewers who have been waiting for the visa numbers to move quickly under the F2B program. The the employment third preference, which is for the professionals and skilled workers, for the world, most of the countries except India, advances by 16 weeks to October 1, 2014. Unfortunately for India, again, not much of a movement, only 1 week to January 8, 2004. Same thing about the EW other workers category. January 8, 2004 is only 1 week advance. But for the other countries, it advanced pretty good. As I said, 16 weeks for the employment third as well as the EW workers category, and the fourth preference, special immigrants, as well as fifth preference, the investment category for $500,000 or $1 million. They both categories remain current. So one other remark I'm going to make, and I'm sure David may have also a couple of comments to make, is that all the time people were thinking that I'm a green card holder, I file a petition for my unmarried son and daughter, and in the F2B category it is taking a long time. So they became citizens or becoming citizens, so that they think that will move much faster. If you look, as what I explained to you, F2B has been moving pretty good. It is August 22nd, 2008, and the F1 is August 2007. There's a 1 year, still they are back than the front. In other words, instead of advancing by becoming a citizen, they are getting back and back. But the good news is there's an option. If you are in that situation, you can opt out and say, I don't want to continue my case in F1. If you are already in a 2B, you say, I want to continue 2B, not going to F1. Your comments.
Right. And that's one of the questions that we frequently get, Michael, is how do you opt out? And so that's obviously something that if you're interested in doing that type of opt-out, we highly recommend that you come to a qualified immigration legal professional to discuss the methodology that's used for that.
And who can make appropriate request
for the opt-out
for the
procedure,
yes.
exactly. I just want to make a couple of quick comments, Michael. As you probably are aware, it's very interesting that we see so much movement in the India employment second preference category. And I think that this all sort of emanates from, or at least this is the thinking, is that it emanates from President Obama's announcement on November 20th of 2014 with regard to these new programs. And many of you may be aware that there was a special memorandum that the President put out that specifically dealt with changing the methodology for counting the visas that are being granted. So one of the things that the President talked about, of course, is streamlining the visa processing procedure. And one of the things they said was that what he wants to do is he wants to make it so that only the primary beneficiaries will be the ones who will take out of the pool and not all the derivatives. Because if we have a family of 10 people, that means 10 of those visas are being taken. And that's the reason why we get the retrogression. Everything goes back because 10 of those visas are being taken out of the pool. And so what the President wants to do is to correct that problem, is to make it so that only the primary beneficiary is the one who pulls from that pool. And that means there are going to be more visas available, which means then that things will advance faster. And it's kind of interesting to see that that's kind of, in a way, what's going on.
Exactly.
So it could be that Charlie Oppenheim, who's the guy down at the U.S. Department of State, who, by the way, issued on March 13th a very interesting view or a prediction about how the numbers were going to run. And for those of you who are interested, please feel free to visit our website. We have an email magazine that we put out that explains what Charlie Oppenheimer is thinking and what his predictions are. And you can take a look at that and you can see how he's predicting what's going to happen in the future. So we definitely recommend that you take a look at that. Also, what's kind of interesting about these numbers, Michael, and I know that you noticed this too, is that China writes itself. So in the past, what happened was the EB3 was going faster than the EB2. Now, all of a sudden, the EB2 is going faster than the EB3. Now, many of you, of course, are not from China, but it's very interesting not just to look at what's happening in India, but to look at the other countries too, because what it does is it gives you a sense of what could potentially happen. It's not that, things can get topsy-turvy. So it's a very, very interesting study, this Department of State Visa Bulletin.
But still, it's sad for people who are born in India, who are in EB3 category, waiting for many years and not moving faster. It's really sad, but we know the law, we know how it works, we know the per quota limit on each country, which is causing this problem. But we hope for the best. आप लोगों को कोई भी इस सिलसिले में सवाल हो, opt out का जो मिस्टर डेविड नार्कमैन ने बताया, तो प्लीज हमको कांटेक्ट कर सकते हैं एनी टाइम फॉर असिस्टेंस. Okay.
And we continue to get calls. Our offices continue to get calls all the time about possibly bumping up to EB1. So EB1, as you can see, as Michael mentioned, is current, and that's a great thing. And a lot of people who have EB2 cases locked in, their EB2 priority dates are locked in, consider the possibility of getting things like publications and notoriety and things like that together to see whether or not you can possibly do your cases in EB1 case. So that's always an option too.
Okay, let's talk about any updates on what is happening on the DACA and the DAPA. Basically, all we know that these are the administrative actions that were announced by President Obama. The one that was announced in 2014, that still is not affected. The first one.
The first DACA program. Right?
DACA program.
I think maybe what we should do is give our readers, our viewers, a quick idea about what's happened thus far, and probably they should know that obviously DACA, the second wave of DACA, we call it expanded DACA, was slated to go into effect earlier in the month, and then what ended up happening,
and DAPA also.
DAPA came through, but it was not supposed to go into effect until May.
Correct.
So we don't really know what's going to go on with DAPA, but we should talk about them. I think Michael's right. We should talk about them together, because what happened was 26 states gathered together and filed a lawsuit in the state of Texas. Judge Hainan, I believe we talked about it on a prior program, issued a restraining order and said that DAPA and DACA cannot go through. So basically what happened was that many different groups, specifically the Justice Department of the United States, went to the judge and said, listen, we're going to appeal this order. We're going to seek a restraining order of the restraining order. But before we do that, we're going to give you an opportunity to basically just dissolve the restraining order. And the judge didn't do it. So what they did is they went to the Fifth Circuit. They've applied now for an appeal. And now we're just waiting to hear what's going to happen with that. Unfortunately, it's not something that's going to happen quickly. So chances are it's going to take some time to work through it. However, the president has vowed and continues to vow that he will do everything possible to try to make sure that this DAPA program and expanded DACA program do go through as quickly as possible.
And I can say that no matter what happens in the Fifth Circuit, this matter is going to go to the Supreme Court either way. This probably end up in the Supreme Court, and ultimately the Supreme Court may have to make a final decision.
Right, and the way it would end up, of course, in the Supreme Court is if you have another jurisdiction that conflicts with the determination.
Yeah.
And that's interesting, Michael, because that might be the best way to move things along, is if there's another jurisdiction that comes down with a contrary determination, and then that pushes it up into the Supreme Court.
So because if we lose in the Fifth Circuit, then we have an opportunity to go to the Supreme Court, and that, I think, better chance of Supreme Court decision is the final. That's the law of the land, and that makes the whole thing very easy and perfect.
Yeah, the problem, unfortunately, is it takes a long time for a case to work its way through the system to the Supreme Court, and obviously these are benefits that are due to people like you, and you can't sit back. You're waiting for your employment authorization documents that the president has, sort of promised, and that's the reality of the situation.
See, not only that, I'm just saying this, thinking broad, that if the Supreme Court says president has the authority to issue these memorandums, executive action, is it possible that President Obama may advance further and coming? For example, I tell you, I've been talking to the clients who are coming for consultations, the DACA's parents, children that got the DACA permission to stay and live and work, their parents are not included in these.
That's right.
The parent DAPA is really only for those people who are illegally in this country and they have a child who is a citizen or a green card holder, but not the parents of DACA, and which is, again, in my opinion, what will happen then if the parent can be deported and the DACA child can stay here? It doesn't make sense. So is it possible, maybe, that Obama, with a little pressure and representation from airline organizations, issue one more memorandum at least, saying, okay, let's go ahead. Supreme Court has said I can do it, I'll do it.
Yeah, I think that your point is well taken. I think that the value, at least as I think we see it, that's coming out of this DAPA and DACA thing is that it's, and I know that a lot of our viewers are probably thinking, well, since they issued a TRO, maybe it's all on hold and we shouldn't even pursue it. It doesn't really make a difference anymore. Right. And they're starting to become very, people are just not caring.
Hold on.
Yeah, they're not caring. But here's the thing. Here's the message I think I'd like to give to all of our viewers, which is a really important one. And Michael, I know you would agree with this because, Michael and I collaborate on the cases that we see. Obviously we have separate consultations oftentimes, and we do that, of course, so that we're able to handle more people.
Yeah.
But we collaborate on the cases. And the one tremendous value that's coming out of the fact that people are coming to see us about DAPA and DACA is that the benefits are not necessarily DAPA and DACA benefits. So what we're seeing is, for example, someone came to see me about DACA yesterday, and it turned out that they had a good U visa case, a victim of a certain crime. And then I had another person who came to see me about a DACA case, and it turned out that they had 245I because they got that benefit from a family member. So what it is that don't give up. Don't think that just because you don't have DACA and you don't have DAPA because of this TRO that you can't do anything, because there might be other benefits that we as immigration professionals can see and help you understand.
David, thank you very much. We are running out of the program. And if you have any questions, comments, or suggestions, please contact us and we'll be more than happy to respond to you. Thank you, David, and thank all of you.
Thank you so much, Michael.
Bye.